Hello guys, and welcome to another episode of Blues Law. Today I'm going to give you the part 2 of the Obrafour, Mantse and Drake case. To start off, let me give you the background of that case. 20 years ago, Obrafour dropped an album. I think over 20 years ago, he dropped an album titled Nyantetepa, and there was a track on it called Oyohene Remix. I think we all know this track. Around 2002, Drake dropped an album. The title is Honestly Nevermind. And this album had a track titled Calling My Name on it, which had a short sample from Obrafour's Oyohene Remix. When you listen to the track, you hear Killer Cut Blood, Killer Cut Blood. When this album dropped and Ghanaians heard this Killer Cut Blood, most of us were happy. Most of us knew that Obrafour had made serious bag from this. After a year or so later, Obrafour dropped this bombshell where he had sued Drake, his distributors, his publishers, in fact, everyone involved in the distribution, the sale, the marketing and everything of this album. Obrafour went guns blazing and he asked for reliefs. Among the reliefs Obrafour asked for were damages of $10 million. According to Obrafour, Drake and his team did not seek his consent before sampling his song. Now, Ghanaians were happy. People were excited. People knew that this was going to bring a lot of money because when the album initially dropped, we all thought Obrafour had made serious bag. But it comes to light that no, Obrafour didn't make anything from this. Now, issues started coming out. On social media, we saw that someone posted an email, which means Drake's team reached out to Obrafour's team, actually. And as a Ghanaian, normal Ghanaian culture, nobody responded the email. And when nobody responded the email, I think the best thing the team could have done was to have let go of that sample. Because in other jurisdictions, in the Western world, an artist cannot just use your sample because they reached out to you and nobody responded. That was the team's first mistake. Shortly after Obrafour's case, we got to know that Mantse, the guy who said Killer Cut Blood, had sued Obrafour. According to him, Obrafour was not the right person to sue Drake. He was. Again, according to him, this part of the beat was taken out of his spoken word work. He had a spoken word called Killer Cut, and this part of the beat was taken from the spoken word work. So according to him, he owned the work and Drake's team should have contacted him, not Obrafour. Obrafour had gone to register this Oyohene Remix in America as his. He registered it as a sole owner. According to Mantse, Obrafour should have added him as a co-owner or a co-author because his work was part of the beat. This case was thrown out of the Ghanaian court for legal reasons which I will not go into because it doesn't matter in this particular case. What matters is that Mantse claims that his work was used in the Oyohene beat. Obrafour should have credited him as a co-author. Now Drake should have come to him directly to seek permission to use that part for his song. Obrafour is not the one to sue Drake. He is the one to sue Drake because it's his work. We don't know the content of whichever agreement Hammer signed with Mantse. He could have given up all the copyright in his work, but in his case, he claimed that he didn't give up any copyright in the work. In this particular case then, he should have been credited as an author. If you check the metadata information on this particular song on DSPs, you see that Mantse is not credited as an author. But if his claims are right, then he should be credited as an author because the sample is his. The work that was sampled is his. So at the end of the day, this case is probably settled, which we already know because we haven't heard anything about it in 2 years. Now there are several questions to be answered here. Was there a producer agreement between Obrafour and Hammer? For now, we don't know. A producer agreement is just an agreement between an artist and a producer, or a label and a producer, whereby the rights of each party is stated clearly. There are terms of the agreement and one of them is warranties. The producer should warrant that he is not going to use any sample without clearing it. Or if he uses a sample that requires clearing, he can inform the artist or the label, and they can take steps to clear it. If it's not cleared, then they cannot move on with it. This case was thrown out of the Ghanaian court for legal reasons, which I will not go into because it doesn't matter in this particular case. What matters is that Mantse should be paid for his contribution to the work, and it should be evidenced by an agreement. Whether he gave up the copyrights in his work to Hammer or not should be in the agreement. We cannot say for a fact that we've seen such an agreement. What we get from this analysis is that always sign contracts. If someone wants to use your work, no matter how small it is, in their work, make sure you sign a contract with them. List out all your obligations, all the terms, and make sure that you receive payment for it. If you refuse to take payment for it, make sure that it's stated in the contract too. Don't just leave it for them to use it anyhow they want, and years later you come back and say that you are being cheated out of some monies that are being made from it now. Sign contracts, take payment for the use of your work. Thank you for staying with me. Like, comment, ask your questions, share with your friends, and see you next week.